this one.
Good.
Need it.
Getting YouTube going. There it is. All right, good morning, everyone. I don't know, we do have the jail. The jail is on. Fantastic. Jail, quick question. Position 7, 6, and 7. It's one, it's the same person. And I think that person is at the South Annex. That lawyer is not available today. There's been a family emergency. So I just need to speak with the defendant for 2 seconds to let her know that, and then the annex can be, well, I guess I don't think we have anyone else from the annex, so we could cut them loose if we were able to connect with the annex, but I'll defer to you guys as to how we work that. But just so you know, position 6 and 7, same defendant, all I need to do is tell her her lawyer can't be here.
Judge, they may have not pulled her.
Oh, because you got word to them about the lawyer?
Correct.
Okay, great. Well, then we'll just see. I'm just trying to save them the time if they were waiting on the line. We'll go in the order of the calendar unless courtroom 2, you tell me we need to go in a different order.
Yeah, we're gonna start with position number 2, and then we're gonna go straight down from there.
Okay, so we'll start with Crosby.
That's correct. Let me go pull them out.
Great. Pardon me, I will let you know. And Ms. Patel and Ms. Hall, if I'm remembering correctly, Mr. Crosby is a drug court referral, is that right?
Yes, Your Honor.
That's correct, Your Honor.
And is it going to be a plea track or it's a diversionary track?
It's a diversionary track.
Okay, well, let's just get him that update. There he is. Hello, Mr. Crosby.
Good morning.
How are you?
Doing well, sir.
Good. I'm Judge McBurney, and we need to talk a little bit about what's happening with your case. I'm going to let the prosecutor give me her update, and then we'll hear from your lawyer, Ms. Patel, who is on this call as well, okay? So, Ms. Hall, what is the state doing with the case? I think it was on for final plea, but it sounds like there may be a non-trial resolution.
Yes, Your Honor, we have come to a negotiated agreement of drug court track 1 for the defendant. He has another case where that was handled through our CWAC division, and I think there were agreements of a signature bond so that he will be able to host bond on that case and go straight to drug court and start handling this case.
The CWAC case is unindicted or has been indicted?
I'm not sure, Your Honor.
It is unindicted. We did reach out to Ms. Nelson, and I believe she discussed addressing the bond with you. Ms. Hodge will be handling the bond because it's a cruelty to children charge.
Do you have the CP number?
Yes, Your Honor. It is 20 CP 192262.
Okay. And is it a consent bond, or was your sense that Ms. Hodge didn't see it quite the same way you saw it, Ms. Patel?
Ms. Hodge was consenting to a signature bond to drug court. I'm just not sure what specific language she may have had in addition to that.
Okay, but we don't need to keep Mr. Crosby or the jail waiting for Ms. Hodge. It sounds like that's something we could handle electronically.
Correct.
Okay, do we know if drug court has said yes to Mr. Crosby or simply that it's been referred for them to consider it?
So, Your Honor, I'm not sure if you remember, Mr. Crosby was a referral in 2019. He had been accepted, everything was good to go, and then a hold had popped up. We sent him to his hold, and they released him instead of bringing him back to Fulton County. So drug court had accepted him, but now I had provided them several months notice of this. But unfortunately, it wasn't until yesterday that I think they met with Mr. Crosby to get his address and contact information. So once they do the verification, we shouldn't have any issues with him starting the program.
Okay. So I'm looking at the 20 CP matter. The judge had to recuse. I wonder why that was. Okay. So we'll work through the bond, but that will give us time also to close the loop with drug court. Do you have any concern, Ms. Patel, that these new charges, the unindicted ones, will cause drug court to reconsider, or were they aware that that was in the offing when you worked with them before?
They were aware. I sent them a police report maybe 5 months ago, so they had that report. It was simply a matter of just making sure that the place that he's going to reside at meets their standards.
Mr. Crosby, do you have housing lined up, or do you need, assuming drug court accepts you, do you need drug court to find you a place to stay?
No, sir, I don't.
Can you say that again?
No, sir. I have a residence that I reside.
You do have a place to stay?
No, sir.
Okay. With whom would you be staying?
Alone.
Oh, you have your own private place, just you?
Sir.
How do you pay for that?
Through housing voucher, United Way takes care of it.
Okay. All right. What part of the city or county is your place in?
Fulton County, South Fulton County.
Okay. All right. So, Mr. Crosby, it sounds like the game plan is this. We need to get final word from drug court. Assuming they accept you, then I'll take care of the bond paperwork for your unindicted case, and then you would be released to drug court personnel. They will come pick you up and get you to a drug court orientation. It's usually on a Wednesday. So it might be that it's not till next week that you get picked up by drug court. I don't control that. But they'll want to get you from Rice Street to drug court for an orientation, and then you will be living on your own, but expected to be participating regularly with drug court. You ready to do that?
Yes, sir, I am.
Okay. Then I guess it sounds like, Ms. Hall, there's not any more paperwork you need to do from the state. We need to know that Mr. Crosby remains accepted into drug court. And Ms. Patel, you'll need to coordinate with Ms. Hodge to get a proposed bond to Ms. Nelson that I would sign, presumably, in a 20 CP case. And that would mean Mr. Crosby would be releasable to drug court.
Yes, Your Honor.
Okay. Mr. Crosby, any questions about any of that?
No, sir, not at all.
Okay, well, I hope it works.
Thank you.
Oh, you should know, just so you're not surprised. So there are 2 drug court judges. I am one of the 2 of them. So you may end up working with me. That's just a coincidence. It's not because I've got your aggravated assault case. I just happen to be one of the drug court judges. So it'll either be a judge named Judge Krause, or you'll be working with me. And we'll make sure that drug court is working with you. Okay?
Thank you, sir.
All right. Thank you.
Got position number 3, Mr. Robinson.
All right. Good morning, Mr. Robinson. Can you hear me?
Yes.
Great. So, Mr. Robinson, your case is on the calendar for a final plea. We're going to see what we're doing with that. Let me see. We've got co-defendants as well. Ms. Snyder, are we able to have the final plea colloquy today?
No, sir. I think the
Why is
state
that?
might have something to say.
Okay. Hello, state.
Good morning, Your Honor. So I guess technically I'm prepared to go forward as it pertains to Mr. Robinson's position. I've been speaking this morning and a couple weeks back with Mr. King, who's been recently retained for the co-defendant, Mr. Slayton. I was able to confirm with Mr. King this morning, actually, that he has not yet, and hopefully Mr. King chimes in if I'm saying this wrong, but that he has not yet been able to get a complete copy of discovery from the previous attorney. I did not know that was an issue. I wish Mr. King would have reached out to me because I'm happy to duplicate it. I don't need him to hunt down somebody for that, but I will make that happen. I'm just going to go ahead and completely duplicate the entire discovery today and get that out to him. So Mr. King's client, I don't believe is going to be a position where they're before Your Honor for a final plea, or they should be before the court for a final plea. But I would like them to track together, but I don't have a reason to ask the court to hold Mr. Robinson for that. Just that I would like them to track together for the purposes of an eventual resolution, but I don't have a specific reason Mr. Robinson can't go forward today for final plea.
Okay. So Mr. Shepard represented Mr. Slayton. And I'm trying to figure out when Mr. King came on board.
Judge, can you hear me? This is Mr. King. This is Imani King.
Good morning.
Good morning. How are you, Judge?
Okay, how are you?
Doing well. I came in late September.
It was actually Mr. Render. Mr. Shannon Render was the private attorney that handled the case prior to Mr. King. He actually argued the previous bond motion before the court, and then Mr. King entered, and he let me know in September when he was taking over the case.
Okay. Looks like Mr. Shepard was allowed to leave the case in late May. And I'm just looking for more. Oh, here's Mr. King. Yep, September 24th, Mr. King joined. So I guess there have been 3 attorneys on the case?
That's right, Judge.
Okay. Are you going to be sticking around, Mr. King?
I'm going absolutely nowhere, Judge.
Excellent. Glad to hear it. So when is it that you concluded you didn't have all the discovery either from Mr. Shepard or Mr. Render?
Well, it's really recently because of the fact that I overlooked the fact that there was a supplemental. So I have the original, but there's a supplemental that I need to look at that I don't have. So that say that in the last week, Judge.
Okay. Well, what I'm going to have you do is get that discovery and look it over. I know you want to talk about bond. I would like you to look over the entire case file before we talk about bond, so that we don't have one of those discussions where Ms. Condry says, well, actually, X happened, and you say, well, I have no evidence that happened. So I think we would have a more meaningful bond hearing, number 2 or 3 for Mr. Slayton. And I know he's not in front of us right now, so we're going to revisit this discussion in a second.
Understood.
But this is helpful to understand what's going on. So,
Yes,
Ms. Snyder, let me go back to you because your client is sitting patiently right there. You have all the discovery, yes?
Yes, sir. I just I haven't received an offer from the state, so I'm assuming it's just the mandatory minimum.
Okay.
It is, Judge. And Ms. Snyder emailed me, I think it was yesterday afternoon. My days are all running together, but I indicated to her that I wouldn't be on this particular matter at this time based on the information available to me and in the discovery. I wouldn't be departing from a mandatory minimum. I did tell her I wanted to check on a juvenile history just real quick to double check that. I was able to confirm that this morning. So that's my that's still my position this morning as it
Okay.
pertains to Mr. Robinson.
All right, and this case, is there anything about it that would make the mandatory minimum something other than 10 years?
No.
Okay, all right. I think we're going to have the final plea colloquy, just so we don't have to bring Mr. Robinson back virtually or in person, given what the state's offer is at this time. And then I don't think they'll fall out of track, Ms. Convery. I understand your concern, but I think Mr. King is going to want to reconvene soon, since he's anxious to talk about bonds. But he'll be determining that time frame, because he'll need to review the discovery that you will graciously provide to the Slayton team for a second or third time. Not Mr. King's fault. Why don't we have that conversation right now? We'll go on the record. So, Mr. Robinson, today is the last day that you could enter a plea and withdraw that plea if you are unhappy with the sentence that I give you. So I want to be clear. You may end up entering a plea in your case. I don't know if you're going to do that or not. That's a decision for you and Ms. Snyder to make. But if you were to enter a plea next week, next month, next year, you would not be able to withdraw your plea if I sentenced you in a way that was more severe than what you asked for through your lawyer. So I'll make it real concrete. Let's pretend Ms. Snyder says, Mr. Robinson, Judge, you should sentence Mr. Robinson to 5 years in jail. And I were to sentence you to 6 years. Today, you could withdraw your plea. If you didn't like the 6, you could say, you know what, Judge, I was willing to take 5, but not 6. I want to go to trial. After today, if you decide to enter a plea and you ask for 5, but I give you 6, you can tell me you don't like that, but that's not a reason for you to be able to withdraw your plea. Do you understand that distinction?
Yes.
Okay. So as I understand it, if you were to enter a guilty plea today, and you don't need to do that, but you can, if you were to do that, Ms. Convery, the prosecutor, would recommend that you serve at least 10 years in prison. That's the mandatory minimum for armed robbery. And those 10 years are non-parolable. So you would do every day of the 10 years. You get credit for the time you've been in, but in the end, you would serve 10 years at a minimum in custody. That would be the state's recommendation. Do you understand that? Yes? Okay. Now, the state's recommendation may change after today. They may learn more about the case and agree to recommend something less. They may learn more about the case and say, actually, 10's not enough. We, the state, recommend 15 or 20. You are facing more years potentially based on what the charges are. But today they're recommending 10. Do you understand that the state's offer, this recommendation of 10, is good for today only? You don't get to tell them next week, well, wait a minute, I want that 10 that you offered me today. You understand that? All right. So what I need you to tell me is whether you are interested in entering a plea where the state would recommend the mandatory minimum of 10 years, and I would have no option but to sentence you to at least 10 years without parole, or if instead you would like to have your case move towards trial so that you and your lawyer can keep working on it and negotiating with the state.
Take the 10.
Pardon me?
I'll do the 10.
So, Ms. Snyder, do you need time to talk with Mr. Robinson?
Yes, please. I haven't had a chance to discuss the state's offer with him since we just talked about it.
Does it make more sense, despite my decision that, okay, we should have this dialogue now, to just have Mr. Robinson come back when we do Mr. Slayton's final plea?
I would appreciate that.
You will connect with Mr. Robinson between now and then to share with him the meaning of the state's offer?
Yes, sir. And I'll be sending you a contact visit order.
Okay. All right. So, Mr. Robinson, we're going to pause. I think it's important, given the stakes of your case, that you and Ms. Snyder have a chance to talk a little bit more about what the plea would mean, so that I'm not discouraging you. In the end, it's your call. It's actually not your lawyer's call. I will not, in the end, ask Ms. Snyder, what is Mr. Robinson going to do? You're going to decide. She may speak for you. That's her job. But in the end, it's your decision. But I think it would be wise if the two of you had a chance to talk a little bit more. So Ms. Snyder is going to spend some time with you, probably out at Rice Street, and she may even be bringing some of the discovery to share with you, so you can watch some of the videos, things like that. Is that a fair statement, Ms. Snyder?
Yes, sir.
Okay. You all right with that, Ms. Convery? If we just, that way Robinson and Slayton will actually move even more so in lockstep.
Yeah, absolutely. And I just want to, I think the court knows, but it's definitely not Ms. Snyder's. Like, I should have been clear with a formal recommendation, even for the purposes of the court's final plea. So I apologize to everybody about that.
That's okay. I wasn't faulting Ms. Snyder. I was
I just
a little by surprise by Mr. Robinson's decision. And given what he said, I think it was more important that his lawyer talk to him a little bit more.
Sure.
So we will reconvene on that. I do want to let Mr. Robinson know and Ms. Snyder know that Mr. Robinson's mother came to court today. She's here right now. And there's not a way for her to communicate with Mr. Robinson. That's not what today's forum is, but it's important for Mr. Robinson to know that that support is out there and that mom came all the way to court, was here on time. And I'm sure we'll be wanting to communicate with you, Ms. Snyder, as you and your client work through this case. Okay?
Sir.
All right. Thank you. So, Mr. Robinson, we will see you again. We'll have this very same conversation again after you and Ms. Snyder talk a little bit more. Okay? All right. Ms. Convery, there's one more defendant. He's not on the calendar today. Am I remembering correctly that there was an ex parte motion about that defendant and we're working through that? Okay.
That's Mr. Collier, and I've been messaging with Mr. Franklin about that this morning as well.
Okay. Do we know, Mr. Franklin, have we gotten any information back pursuant to your request?
No, as of yesterday, when I was last in the office, I have not received any documentation.
Okay.
It is about time for me to reach out to like my social worker to see if maybe they received it or it was sent to another judge or something, because I would have expected it to be back around now.
Yeah, we have a pretty good channel that's been formalized that I get it and whatever attorney, so I think it would be you requested it. You and I and Ms. Nelson would get it electronically. So we may need to, and if you need my help, let me know, nudge the right folks to make sure that this is getting taken care of.
Yes, sir. Every once in a while, I'll get one that goes to the attorney who was originally on the case.
Right.
Someone who was in mid-complex, and when it should have come to me or come to the court. So it may just be that situation, but I'll put highlight it to reach out to somebody in my office who can get in touch with the doctors fairly easily.
Okay, yeah, if that happens, usually we try, Ms. Nelson and I try to get it to the attorney of record, because if it goes to Ms. Jernigan or Ms. Bray or someone, just because their name was in the docket, we do try to get it to you. But why don't we check and if you're getting any friction back, let me know and we can try to expedite it.
Yes, sir.
All right. Is this Mr. Slayton? Good morning, Mr. Slayton. How you doing?
Good morning.
Mr. Slayton, your lawyer, Mr. King, is on this call. You can see him. He's walking through his home, it looks like. I just want to let you know, and I'll let Mr. King add to this, that Mr. King, relatively new to your case, figured out that there was some discovery that the government had given to your earlier lawyer that didn't make its way to Mr. King. And he needs to be able to review that discovery so he can talk with you about it. He may want to review it with you, and I can help him do that if he needs to share some things with you before we can talk more about the case. There are two things that I thought we might do today. One was talk a little bit about bond, and the other was to talk about your final plea, which is the last date that you could enter a plea and still have the ability to back out of that plea if you were unhappy with the sentence. We're not going to do either of those today because Mr. King needs a chance to read and digest this additional discovery. It's important material. It may make Mr. King think differently about your case. He may think that you've got an even better defense. He may think that you're in maybe a little bit more of a bind, and that might affect how he talks to you about what the next steps are in your case. So that's a long way of saying we're not doing anything today. It's just more of a check-in, but it was important to get Mr. King and Ms. Convery, that's the prosecutor on your case, and you and me all in the same space, if not the same physical room, so that we could make a plan. I'm going to ask a few questions of the lawyers, then I'll see if they want to add anything, then I'll see if you have any questions, okay? Ms. Convery, how much time do you need to get another set of discovery to Mr. King?
I should be able to make that happen by tomorrow morning. Like, I should be able to have it out to him by tomorrow morning. I asked Mr. King if he preferred to pick it up or have it mailed. I think he says he'd like for me to stick it in the mail, so I will have that out by tomorrow morning. I'll make that a priority today.
Okay, so Mr. King, assuming you get the discovery late this week, early next week, how much time would you like to work through that on your own and potentially connect with Mr. Slayton?
Judge, I would just ask for, honestly, I just need a couple of days. Knowing the time is of the essence, and I don't want to waste anyone's time. As soon as it's available, even though I did ask Ms. Condry to mail it, but understanding where we are now, I'd rather just go pick it up tomorrow if it's available.
That's fine.
Picking up tomorrow would allow me to meet with my client over the weekend, and then anytime past this weekend, Judge, is when I would be willing and able to do a bond.
Okay, well, I will work with Ms. Nelson to figure out a date when we can reconnect and get everyone together. I noticed Ms. Singleton has just made herself visible. Good morning, Ms. Singleton.
Good morning.
Do you have anything you wanted to add on Mr. Slayton's situation?
No, Your Honor, I'm just waiting for the bond hearing.
Okay, we're not going to do that today. Mr. King needs to get some additional discovery so he has a fuller picture of what connects or doesn't connect Mr. Slayton to these serious charges. So we will be sure to get a new date set in the near term so that we can revisit that. Mr. King, I guess what I'd like to do, we can talk on, but I'd also like it to be the final plea date. This case has been around for a while. That's not your fault. It has bounced between a few lawyers. But I'll talk with Ms. Nelson about a date when we can get Mr. Robinson back here after Ms. Snyder's had a chance to meet with him. And we can get your client back here. But I'm comfortable separating the two because those would need to be in person, meaning someone's on the screen at least, if not physically in court. The final pleas would. The bond hearing, we could decouple it if you are waiving Mr. Slayton's appearance for that. If you need Mr. Slayton to be plugged into the bond hearing, which is fine, it's his right to be there, then that's a different scheduling question than simply getting you and Ms. Convery and Ms. Singleton all connected on a Zoom call.
Judge, I would ask that we waive his presence to do the bond hearing as soon as we can. He does have some supporting parents who are on our call today, mother and father. And I know any.
You're not taking it down, right? That's good. Okay.
We set the bond hearing as soon as we can, and I will waive my client's presence and his family. You know, he's 17. He turned 17 while he was in custody. His family will be available for that hearing.
Okay, well, we'll get the date out far enough in advance that people can plan for it. And we'll get on the record when we do the bond hearing that you are waiving Mr. Slayton's presence. And I'll engage Mr. Slayton on that in just a minute. So there'll really be 2 dates coming up in the near term. Sooner will be the bond hearing, and then we would get to the final plea. Mr. Slayton, we just talked about your situation a whole bunch. Did you follow what we were talking about? So Mr. King is understandably anxious to have your bond hearing sooner rather than later. And he has told me that it's okay for us to talk about your bond without you dialing in. Are you okay with that?
I mean, I wish I'd rather be there so I can know like what's going on. So I
can you say that one more time?
Yeah, I'd rather be there so like I can know like more information what's going on so I won't be confused.
You said you would rather be there.
I said I'd rather be there so I know what's going on so I won't be confused. So like instead
Okay,
of
I'll tell you what, I'm going to let you and Mr. King talk through that. And then Mr. King, you can let us know. But that needs to be Mr. Slayton's decision as well, okay?
Absolutely, totally understand.
So, Mr. Slayton, we will see you soon. It may be that we see you like this via Zoom. We also have the ability once a week to bring some inmates over. So it may be that we bring you over to this courtroom. We'll figure that out. And we'll talk more about your case. In the meantime, Mr. King, you're going to come by the DA's office tomorrow and personally pick up the discovery. Is that correct?
That is correct.
Okay. Ms. Convery, anything else on Mr. Slayton's case?
No.
Mr. King?
No, Judge.
All right. Thank you.
Thank you.
Position number 5, Mr. Roberson.
Good morning, Mr. Roberson. Can you hear me?
Sir.
Great. All right, Mr. Roberson, we're going to talk a little bit about your case. Today is your final plea day. I think we can have a final plea conversation, but let me start by asking your lawyer, Ms. Snyder, if she thinks that's what we ought to take care of today. Ms. Snyder,
Yes, sir.
Pardon me?
Yes, sir. The offer is the mandatory minimum, which is life. So.
Okay. All right. So any reason we should not move Mr. Roberson's case to a trial calendar?
I don't believe so.
Okay. As far as you know, it's trial ready from your perspective.
Getting there.
Getting there. Okay. Ready enough that by the time we could try it, it would be trial ready.
Yes, sir.
Okay. Mr. Pinion, is Ms. Snyder correct that the offer on the table right now for Mr. Roberson would be to plead to the indictment, which would mean at a minimum a life sentence?
As of right now, yes, sir.
Okay. So, Mr. Roberson, your charges are more serious than the typical case we see. And so the conversation that I normally have is, let's hear what the state's offer is. And I'm making this up, but it might be 10 years to serve. And you would let me know today, you know what? I still want to try a guilty plea because my lawyer's going to ask for less than 10 years to serve. And you might give me less than 10. And then I would take that plea. But your case, given the charges, the state's only offer right now, if you wanted to enter a plea, would be to plead to the indictment. And the lowest sentence I could give you would be a sentence of life. And so what Ms. Snyder is suggesting is that it probably makes more sense for you to have your case move on to the trial calendar. I'm assuming you're not interested right now pleading to a life sentence. Is that correct?
This is the first time I'm hearing anything about this. I haven't got a discovery pack. I haven't got anything
really don't know what's really going on with anything.
Well, two different things. It may be that you and Ms. Snyder are going to talk more about the specifics and what all is in discovery, et cetera. But I trust you understand that you're charged with felony murder. You're not thinking that you're in jail on shoplifting. Is that right?
I understand.
Okay. So
just ask Mr. You said you didn't get your discovery packet in the mail?
No, ma'am, I haven't.
Okay. That's good to know.
Sounds like Ms. Snyder will send it out again because she's tried to get it to you. But what I'm going to do, Mr. Roberson, is have your case moved to a trial calendar. As you figured out, we're not doing trials quite yet. We hope to start up trials in January, and we're going to see how an initial trial goes. And if that goes smoothly, then we hope to slowly and gradually and safely expand the number of trials that we can do here in the courthouse, so that by early next year, we may be in a position to get you into court for a trial if that's what you want to do. Of course, you and Ms. Snyder may talk about the case and talk with the prosecutor and come up with a disposition that doesn't involve going to trial. And you're free to do that. But for now, we're moving your case to trial calendar because it sounds like, understandably, you're not interested in pleading to the murder counts. Is that correct? Okay. All right. Ms. Snyder, other than needing to mail out again a discovery packet to Mr. Roberson, anything else we need to talk about?
No, sir.
Mr. Pinion?
No, Your Honor.
All right. Well, Mr. Roberson, you'll be talking with Ms. Snyder, and the next time we connect with you, it'll be to figure out when we're getting your case to trial, okay? Thank you.
Good morning, Judge McBurney.
Hey, good morning.
This is Officer Milton here at South Annex. I have Miss Tucker, if you're ready for her.
Hold on, Milton.
Okay.
Judge, about Ms. Tucker, I spoke to Ms. Hall this morning and the offer is just a little bit different. So if you could put me in a breakout room with her, I'd like to discuss the new offer.
Okay. Officer Milton, can I get you back on for 1 second?
Yes, sir.
Hey, good morning. Thank you for being there. Do you know that we don't need to meet with Ms. Spikes?
Yes, sir.
Great. Her lawyer has a conflict, can't be here. So we will see Ms. Spikes soon. And we'll get to Ms. Tucker in a minute. It sounds like Ms. Tucker's lawyer, Ms. Snyder, would like to chat with her for a sec. If I move your tile and Ms. Snyder's into a conference room, can they chat?
Yes.
Great, I'll do that. And then we'll go to whoever is on the screen in courtroom 2. Hold on 1 sec.
Thank you, Judge.
You're welcome. All right, should be open. Great.
All right, Your Honor. This is add-on 1, Mr. Grimes, Isaac Grimes.
Okay. Thank you. So, Mr. Grimes, I think his case, Mr. Franklin is handling, and thank you, Mr. Franklin, for stepping up. My file says Mr. Shepard all over it. I think we've got 2 prosecutors on the state side. Mr. Grimes' case has come to our attention because of some concerns about his well-being. I think I'll start with you, Mr. Franklin. Why don't you tell me what you understand is going on?
Yes, sir. So at this point, I think we are at 223 days in custody for Mr. Grimes. He is being held on both a probation warrant. The warrant is for an armed robbery case. I'm not sure that the details specifically are that important, I will say that from what I understand and speaking with Mr. Williams, that Mr. Grimes was more of the involved accessory, more so than the most culpable person. He is currently being held also on a entering auto charge. And I believe there's a misdemeanor carrying a concealed weapon that is involved with it as well, and a misdemeanor obstruction. I believe the court and Mr. Williams, and I brought Ms. Hall in on this because I believe she would be the person that's responsible for the entering auto charges. Everyone's aware of the safety concerns. And so I received the email from Ms. Nelson, reached out and, got on the ball as quickly as I could. And I quickly realized that we are only involved technically with the revocation matter. But even if we were to resolve the revocation, which Mr. Williams and I have reached an agreement on, he would still be held in custody on the entering auto. I spoke with Mr. Grimes. I sought to, I don't have an actual file, and from what I can tell from the attorney in my office who had the case, Jade Valman, the only thing she recalls being in the file was the warrants and some other. So speaking with Mr. Grimes, I understand that he may have been brought into custody for that case off of a videotape where an officer looks at the tape and says, "Oh, that's Isaac Grimes." And so there's certainly several ways that can be interpreted, and that videotape would be necessary for us to evaluate the propriety of him entering a plea to that case. So although I have not filed a bond motion, given the quick turnaround of this request, I did call a heads up that I would be asking to address bond. I'm not sure if she's been able to get in contact with the persons whose cars were broken into. And so I understand that may present a conflict, present an issue rather, in addressing bond. I have received communication from the family doctor for Mr. Grimes. He has agreed to make a referral to a mental health person to assist Mr. Grimes in those matters with which he's dealing. He has lost his grandfather since he's been in custody. He has become a father and has not yet seen his 3-month-old child while being in custody. And just a lot for a young man to be dealing with. I think he's just responded in not the best way. So my goal on behalf of Mr. Grimes and his mother, Ms. Harris, is to try to figure out a resolution that addresses the revocation, which I think we have, but also converts his current $7,500 bond into a signature bond on the highest conditions.
Okay, yeah, I'm looking at the bond. I didn't realize, I was confused as to how he would be in no bond status. He's not. There is a bond order, and it is, as you said, for $7,500, and ankle monitor and a curfew. This was Judge Oliver, a bond she set back in April. That's an amount that is beyond Mr. Grimes's family's reach, Mr. Franklin, or they haven't tried to post it because there was a revocation hold anyway, so why post the bond?
So yes to both. So they haven't tried to post it because of the probation revocation, but in my conversations with his mother, she doesn't have it herself. She could try to call around to other families, see what they have. But that's why I mentioned in the email about the fact that she paid a private attorney who feels he was paid to get the case on a calendar. Okay. And so that's what I understand, that was $750, which largely
would have been the bond.
Been the 10% that would have allowed him to make this bond, but could have been the bond. And so, maybe a more thoughtful expenditure of resources would have allowed him to make bond under normal circumstances. But I think that we would be playing that game of, well, we'll come back in 2 weeks or 3 weeks and be asking the court again to convert after we've displayed that we can't make bond. And again, given the safety and health concerns that we discussed.
Okay. Well, let me hear from Mr. Williams. Mr. Williams, Mr. Franklin is saying that on the revocation side, you and he have reached an agreement. Is that a fair statement?
Yes, Your Honor. And I would just acknowledge for Your Honor that the original victim is Miss Daniels is on the call as well. I'm grateful that Miss Singleton is on the call too, because she was involved in the underlying case. Mr. Franklin picked up the case quickly and has stated accurately that the recommendation would be for to essentially time served and to reinstate with the condition that he comply with the recommendations of treating physician regarding mental health, and try to get him in a mental health track for probation, which I believe he was on, but just make sure he's still on that. Yes, sir.
Mr. Grimes, how old are you? You say that again?
Your Honor, I'm 18-year-old. You're 18-year-old.
You're 18 now?
Yes, sir.
Okay, thank you. Ms. Hall, you would be helping out with the CP case just because you're helping out. I mean, it doesn't really belong to any particular division yet, but there's no reason why we can't work through the CP case. But in terms of talking about a bond or modifying the bond in the CP case, you will be the spokesperson for the state, or is that going to be Mr. Williams?
So, Your Honor, I was trying to figure out the state's appropriate position in this case, seeing as though we had the conflict off the original case. So I reached out. I haven't had a response back from my supervisor to understand how she wants me to move forward. So I actually was going to give it to the court in your discretion, because I understand everything that has happened in this case, and I have not been successful in reaching the victims to understand how severe the enter an automobile case is. So I was going to leave the bond as far as the new case in your discretion, because I haven't gotten confirmation back from my office as to how to proceed as far as if I'm representing the state in the CP case. What was the conflict in the armed robbery case that caused your office to come off? Miss Daniels, who was on the call, she was a colleague, but she's also my friend in life, in real life. So it was a double conflict for us. Sure. Okay. Well, I appreciate Mr. Williams getting involved and staying involved. I am getting some information that suggests that Mr. Grimes may have a hold from South Fulton. Yeah, it's for a gambling charge. He was outside with some people and they were throwing dice, is what I've been told. Okay. So, and I think he may have his court. It could be for jaywalking. We just need to work through that as well, I guess. So we might be able to collectively clear things up so that the county jail says we're done, but then I just want everyone to understand it might be that Mr. Grimes then has to go to South Fulton. But it sounds like you're aware of that, Mr. Franklin. How does that work? I'm aware of it. Who would help Mr. Grimes in South Fulton? Does your office cover the municipal courts, or his family has to work through that? We don't normally cover those things. I have had situations where, not necessarily municipal court, but I have gone to other jurisdictions, Douglas, Hall, Cobb, Gwinnett, where the nature of my representation in Fulton has led me to want to make sure that I see a certain thing out. And so I would, once I see that he's checked out of Fulton or booked out of Fulton, I would reach out to his mom and see if she's gotten any word from South Fulton as to whether they're going to hold him, if they're going to go ahead and release him back out, given the nature of the charge. And if he's not, if it doesn't appear he's going to be released immediately, I just do what I have to do to make an appearance in South Fulton Municipal Court. Okay. And I typically don't have to ask special permission for that kind of thing. Okay.
Ms. Crawford, how much time remains in Mr. Grimes's 18 SC case?
Judge, he has 13 years, 1 month, and 10 days remaining.
Oh, okay, so plenty of time. Thank you for sharing that. Ms. Daniels, are you the 638553? Is that you?
Yes, Your Honor, it is. Good morning, everyone.
Good morning. Anything you want to add? You've been listening quietly, and I appreciate you being plugged in. Anything you want to add as I think through what to do with this revocation petition?
Your Honor, I would just ask that the court follow the, or accept rather the recommendation of both the state and defense counsel on the case. The instant case, Your Honor, with the probation matter, Mr. Grimes was cooperative, and do believe that he would have continued to be cooperative had it not disposed of by way of plea.
Okay. Well, I appreciate you sharing that and taking that perspective on the situation. Ms. Singleton, anything you're going to need to remind me? Mr. Grimes is now an adult by any yardstick legally, meaning state or federal. Are you still involved in his supervision in any way?
No, Your Honor, I'm not. I initially supervised him on the armed robbery case when he received the bond. He also was given the opportunity to have the DJJ early release hearing. At all those points, his mental health was taken into consideration. It was known, it was part of his bond and part of his sentence for the armed robbery that was reduced to robbery is that he be placed on a mental health caseload with probation. I'm not sure if that occurred. Hopefully it did. I know that when he initially was released, his mother did have some difficulty with probation. And so I did speak with probation, send them the paperwork, remind him that he was to be on a mental health caseload and try to assist the mother with getting him plugged back into his doctors. So that was really the only information that I had concerning that case. My understanding of what was said today was that he has like a $7,500 bond on one of the charges, as well as an ankle monitor. So I just want to point out to the court that his mother would have to pay for that ankle monitor as well if that continued to be a condition, as well as whatever the bond is.
Okay.
That was going to be part of my request as well. When I asked that he be put on pretrial at the highest supervision level, the other half of that would have been that the higher supervision level we would ask kind of be traded out for the money that would have to be paid for the ankle monitor. Thank you, Ms. Singleton.
No, I suspected that was the purpose of asking for level 3. Okay, Ms. Crawford, do you know if Mr. Grimes had been working with a probation officer who was attuned to his needs?
Judge, I'm looking at the notes now, and I don't see where it's notated that he had a mental health officer.
Okay, well, we'll try again. I'm looking at the final disposition that Judge Reeder signed in January of last year, and it required Mr. Grimes to live at an address in Riverdale. Is that where your mom lives, on King Road, Mr. Grimes?
Your Honor, that's my grandmother. That's my grandmother.
Grandmother's house. Okay, is that where you were living before you got locked up this time?
Yeah, I was living with my grandmother, but I was time to time back to my mother's house.
Okay. Mr. Franklin, do you have any intel on what the right address would be? I don't mean what's the street address, but is it wiser to have Mr. Grimes at grandmother's house in Riverdale or at mom's house, wherever that is?
I'm sorry, the audio was coming in now.
Okay. The question is, the original sentence for Mr. Grimes required that he live with his grandmother in Riverdale. And Mr. Grimes just mentioned that he's actually trying to get to live with his mom. I'd like him to be in whatever environment is most supportive and will keep him out of the most trouble. So I just didn't know if you had any insight as to if the family dynamic has changed and it makes more sense for Mr. Grimes to be with mom or with grandma.
I don't know anything in particular. All of my communication has been with mom, but I don't know. I don't have any information to say whether with mom or with grandma is a better situation or not.
Okay. All right. So what I'll do, Mr. Grimes, I do find that I take it, Mr. Franklin, that Mr. Grimes is stipulating to the allegations of the petition for revocation.
Yes, sir.
Okay. So, Mr. Grimes, I do find that you violated the terms of your probation. And what I would do is, you've been in since when did you get locked up?
Your Honor, I got first incarcerated March the 25th.
March the 25th?
Yes, sir.
All right. So what I'm going to do, Mr. Grimes, is revoke 9 months of your probation, but I'll reduce that to time served because 9 months would get us a little into December. And then I'm reinstating the balance of your probation. So you still have lots of probation ahead of you. I'm going to emphasize on the order that I signed that you should be assigned to a mental health probation officer. Ms. Crawford, you can put the magic language in there. I want to refer to it as the right thing, but I'd like you to be working with a probation officer who is attuned to what's going on in your life. I'm going to hold off, Mr. Franklin, on indicating where Mr. Grimes needs to live. That'll be in that order to give you a chance to talk with mom. Are you able to reach her pretty regularly, or?
Yeah, we've talked each day since I've worked on stuff. So,
all right. Well, if you wouldn't mind talking with her and then getting to Ms. Nelson, the address where Mr. Grimes should be, whether that's mom or grandmother, and that'll be where he needs to reside. You'll need to continue to stay away from the victim in your case, Mr. Grimes, as well as your co-defendants, the Johnsons. You'll need to stay away from them and keep working on the other things you were supposed to be working on. I'll also set a bond in your entering auto case that will get you out and will subject you to level 3 of pretrial supervision, which means you're checking in pretty regularly with some folks so they know where you are and what's going on. You need to know if they can't find you for some reason, they're going to reach out to me and I'll probably tell them to come off the bond, in which case we'll just get you back to where you were, which is not a smart idea. What I cannot help you with is this hole down in South Fulton. So it may be even after I sign everything, the folks at the jail where you are now send you to a different jail because it sounds like you may have a gambling charge. You'll need to work through that. Mr. Franklin may be able to help you with that. I can't require him to do that, but he's the kind of guy who will want to see this through to make sure you are in an okay space. So we'll see what happens with that. I think that covers everything. Mr. Williams, anything else that you think we need to work through on the revocation side?
No, Your Honor. Thank you.
Okay. Ms. Hall, in terms of the CP case, with a bond being set, I think it's wise for you to disengage because if this case were randomly assigned to my division, which it would just be random, you would need to not work on it anyway because of Mr. Grimes's older case. And so if there's a way to get the case accused, and Mr. Franklin, you're holding on to it, I'm happy to work through its disposition. We just need to find a different prosecutor, maybe someone from non-complex or something. But if you're looking for it to get resolved quickly, you're welcome to reach out to Ms. Nelson and we could get it on a schedule. And I think that covers everything. Anything else, Mr. Franklin, for Mr. Grimes?
No, sir. I just want to thank everybody for being able to get stuff together so quickly on it. I know we had to hustle and a lot of arms and things were involved. And thank you and Ms. Nelson for getting on the calendar so quickly, and Mr. Williams and Ms. Hall for responding to my request so quickly.
All right. Well, it was important for us to focus on this based on what was going on.
Your Honor.
Yes, ma'am.
I apologize. ISP is actually the highest pretrial level, which would also afford him field visits once we open up a little more. So I just wanted to point that out to the court.
Okay, well, let's do that. I had forgotten that that was even an option. So we'll do that for the bond. That can be dialed back if the CP case gets resolved. Mostly, Mr. Grimes, we're just trying to keep you out of, oh, you sent a text to that effect too. Keep you out of trouble, okay? Do you have any questions about any of the stuff we talked about?
Yes, Your Honor. Can you tell me what the bond have been set at, Your Honor?
So the bond is going to be a signature bond in the end, so the dollar amount doesn't matter so much. It'll be something that you can get out for. And that's how we'll leave it for now. If there are problems with the bond, I may need to change that. But I don't want you or your mom worrying right now about the bond amount. You're going to need to sort out the situation.
Your audio is.
All right. I got to go take another call right now. Is there anything else we need to do in Mr. Grimes's case?
Just making sure that the, in addition to being on ISP, that the ankle monitor request has been.
There'll be no ankle monitor.
Yeah. Okay.
And Mr. Franklin, I can't sign the revocation order until you confirm with mom and or grandma what the right address will be that we'll require. Because I'll put that on the bond as well. That'll be the address where he needs to stay. Okay.
Yes, sir.
All right. We're going to be on hold for about 10 minutes. And when we circle back, hopefully we can take care of Ms. Snyder's case. Thank you, Ms. Daniels, again for joining us.
Thank you. Continue to be safe, everyone.
All right. I'll be right back. Do another call. Wait for it.
All right. Good morning, Ms. Howard. We're taking a break. We're going to start you up in about 15 minutes, okay?
All right. You can hear me?
Yep. I hear you loud and clear. Your phone charged all the way, right?
Yes, sir.
Okay.
Oh, she had transferred me too. I hung up and got on court. She transferred me, but I hung up and got on court.
Ms. Howard, you want to probably put yourself on mute because we can hear you.
Okay, sorry.
No problem. We can still hear you, Ms. Howard.
Oh, that's my little boy in school on his computer. We in the car. Oh, wow.
So you're not able to mute?
Cause that's, I can mute. Yeah, I can mute. Let me see.
Okay.
Miss Terica Day, if you're in court, I'm going to be giving you a call on your phone.
Who are you here for? For what case? You know, what's her last name? Is she on the calendar? Day? Day.
Terry Cadet,
Yeah.
her attorney just announced that she's gonna give her a phone call if she were in the courtroom. I didn't know if she'd been here or not, so.
Okay. And she actually just went out to take it.
Okay, good. Sure.
Remain seated. Remain seated.
Okay, we're back. Sorry for that delay. It took a little longer than expected, but it got put on my calendar yesterday, and we didn't want to cancel all that important jail stuff. So I think where we left off was to have a conversation with Ms. Snyder, and let me get to the right position on here. Ms. Snyder, where are we? It's position 1, I guess. Ms. Tucker.
Yes, sir.
Okay, great.
That'll be a negotiated plea this morning.
All right. Ms. Hall, you're still with us? There you are. I have to find all the little faces. We've got a lot of folks on this call. I don't know who is Galaxy A10E. Who's at that number? Were you expecting Ms. Snyder to have anyone on the call?
No, sir.
Or in connection with Ms. Tucker?
No, sir.
Okay. How about Denise Howard? Ms. Howard, who are you here for?
She's on the 10 o'clock calendar, Your Honor.
Look at that.
Position 1.
Got it. All right. So she's in the right place. Well, then let's just go forward with Ms. Tucker. Ms. Hall, are you ready?
I am.
Great. Well, we'll get on the record. Are you able to hear me, Ms. Tucker?
Yes, sir.
Great. And I can hear you. That is perfect. My understanding, Ms. Tucker, is that you're going to enter a plea in your case. Is that correct?
Yes, sir.
Ms. Hall, is it a plea to the charges, or is anything being changed?
Nothing's being changed. It's a plea to the charges.
Okay. So Ms. Tucker, in just a moment, Ms. Hall is going to put you under oath. You'll raise your right hand and she'll swear you in. Once you're under oath, it's important that you answer all of Ms. Hall's questions and my questions truthfully and completely. Will you do that?
Yes, sir.
It's just as important that you let me or Ms. Snyder know if you've got a question about anything, because I need to be comfortable that you have heard and understood all the things we're talking about. So will you let me know if there's something we say that you don't understand or you can't hear?
Yes, sir.
Great. Last thing, and then I'll let Ms. Hall take over. Normally, there's really not normal anymore, but normally you'd be here in court and Ms. Snyder would be sitting right next to you. but you're down at the South Annex and Ms. Snyder is in her home office. Do you waive your right, Ms. Tucker, to be here in open court?
Yes.
And do you waive your right to have Ms. Snyder by your side?
Yes.
If something comes up where you need to speak with Ms. Snyder in private, just let me know and we can do what has already happened today. Put you and Ms. Snyder into a breakout room so the two of you can speak privately, okay?
Okay.
Great. Ms. Hall, when you're ready.
Thank you. Ms. Tucker, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes.
You may lower your hand. Please state your true, correct, and legal name.
Wakilia Tucker.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
I've taken my medication for today already.
Will it affect your ability to understand what's going on in this proceeding?
No, ma'am.
How old are you and how far have you gone in school?
I'm 42 and I went to the 9th grade.
And are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with battery, family violence?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
I'm satisfied.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
We are unaware of any defects for the purpose of this plea, so waived.
Do you waive moving forward on a copy of the indictment?
So waived.
Ms. Tucker, have you been arrested on these charges?
Yes.
I ask because the state is unaware of any outstanding warrants that are related to this charge. Do you or your attorney know of any outstanding warrants related to this charge?
No.
Okay. Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 5 months probation to serve? I'm sorry. I'll restate that. The state's recommendation is 5 months to serve. But the court does not have to accept that recommendation. The court can sentence you to the maximum on this charge. Do you understand?
I understand, yes.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand it? I'm sorry, do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights?
Yes.
I'm gonna give you a list, Ms. Tucker, and at the end you can answer if you understand. The following rights are the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Understand.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
How do you plead to the charge of battery family violence in indictment number 19 SC 173687?
Guilt.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
I understand.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
I understand.
Thank you. Your Honor, had this case proceeded to trial, the state would have proven that on March the 24th, 2017, at 3737 Atkins Road, Northwest Atlanta, Georgia, officers were dispatched to that location, that address on an unknown 911 call. When they arrived, they spoke with a roommate outside that said that his roommates were inside of the home fighting. When the officer approached the inside of the house, he went inside and he noticed the defendant and another victim, victim, Mr. Richardson, who was also arrested, Your Honor. They both were covered in blood. The officer could see bruises, clear bruises on or injuries on both the victim and the defendant in this case, or both defendants. The male had a laceration on his forehead. The officer said it looked as if he was hit with something on his forehead. Ms. Tucker also had various injuries on her body as well. Both Ms. Tucker and Mr. Richardson was asking the police who called them. Neither one wanted the police there. They just wanted the police to leave. But the officer did say that, report that from his observance, it looked like they both were engaging in fighting before he got there. So he arrested them both. This case is 3 years old, Your Honor, and we have decided to the defendant, Ms. Tucker, has been in custody for a little bit over 5 months. So we have decided to the recommendation to be the 5 months to serve with no additional probation. She does have some prior convictions. I'll let Ms. Crawford explain her criminal history to you, though, Judge. That is all from the state.
So the state's recommendation, it sounds like the negotiated resolution, is 5 months to serve, no probation, just move on and stay out of trouble.
Yes, Your Honor.
Okay. Ms. Crawford, what Georgia criminal history do you have for Ms. Tucker?
Judge, she has 3 prior felony charges. The first one is a 06 case. It's 06 SC 50308, theft by receiving stolen property. And then she has a 2007 case, obstruction of law enforcement, also with the misdemeanor attached to it. And then her last case is a 17 case, 17 SC 156434, aggravated assault felony, all inactive.
Okay, I'm gonna look up that one case, but currently not under any supervision, it sounds like.
That's correct.
Okay, Ms. Hall, Aaron Richardson, who is the victim named in this case, is a defendant in another case, or was a defendant in another case?
He was also arrested in this case. Well, I'm sorry, I may have misunderstood your question. Can you ask it again?
Yeah, I didn't ask it well. You mentioned they were both arrested. Were there charges brought that your office pursued against Aaron Richardson?
Not the Superior Court, but state court. The reason why Ms. Tucker is in Superior Court is because she had a prior battery that made her battery a felony. So they both were arrested on misdemeanor charges, and then her charge got bumped up.
Yeah, actually, she had an ag assault against Aaron Richardson. That's the aggravator in the indictment, is this 17 SC case. So let me ask Ms. Snyder, Aaron Richardson is male or female?
Male.
Male, okay. And what is the connection between Mr. Richardson and Ms. Tucker besides fighting?
They used to date, but they have not been in contact with each other since this incident in 2017.
The ag assault was actually later in time. This family violence battery even though it was indicted in 2019, occurred on March 24th of 2017, and the ag assault was in December of 2017. So they clearly had contact after March. Maybe it's after December they stopped having contact?
Right. Since 2017. Miss Tucker had some mental health issues and she was not taking her medication at the time. She was also drinking. And that's where this incident stems from. They were both drinking and got into an argument, which led to a physical altercation. But since that time, Miss Tucker has gotten into stable counseling, and she is taking her medication regularly. She has stopped drinking. She has not had anything to drink since she wrapped up her case in 2017, 2018. She doesn't see Mr. Richardson anymore. She lives at home with her mother on Magnolia Way. Her mom's left me several voicemails, so she does have significant family support. She has her therapy, and her mom, we've spoken about, she has some jobs lined up for her. So
Okay.
we would ask that you accept the plea as negotiated.
Okay. Ms. Tucker, good morning. Tell me what medications you take.
I take Depakote for bipolar disorder, and I take Trazodone for insomnia, for sleep. I take Paroxetine for anxiety, and I take I can't pronounce it. It's a big word. It's a shot.
And what's that help you with?
My bipolar. I take like 3 meds for bipolar. So I'm over on Boulevard. I go to Boulevard for my mental health. Matter of fact, I have a mental health appointment coming up. My mom just told me yesterday.
Okay.
Yes, and so I'm going to take counseling classes there. I found out they're for free, and alcohol and drug evaluations there also.
How will you be able to get your medications when you get out of jail?
I'm on the $4 list for 3 of them, and 2 of them I get them at my doctor's office.
Okay.
So I don't have to worry about paying no big money and no excuses for going without my meds.
Are you able to stay at your mother's house when you get out?
Yes, sir.
Okay. You thank your mom when you get home. And
Yes,
your
sir.
plan is to get back to Boulevard to see the doctor and get your meds and whatnot.
Yes, sir.
Okay.
Right away.
You took whatever you're supposed to take this morning. Did you take it?
Yes, sir, I took it.
When you take those medications, do they leave you woozy or confused or groggy, or do they actually help you understand what's going on?
They help me to understand what's going on.
Okay. Have you understood all the things Ms. Hall was talking to you about?
Yes, sir.
Do you have any questions about anything we've been talking about?
No, sir.
Ms. Snyder, is Ms. Tucker in jail because she didn't show up for court?
It was a direct indictment. It's a 2017 incident. And she was arrested on a misdemeanor. She was released from misdemeanor court, and then it was directly indicted in theory in Superior Court. And she just didn't know about until the grand jury warrant. She got picked up on the grand jury warrant.
Okay. Ms. Tucker, when's the last time you saw Mr. Richardson?
I haven't seen him since that incident. I left and I went and stayed with a cousin of mine, and I haven't seen him. I talked with his father, and he said that he went back to New Jersey. He have kids in New Jersey, and his ex-wife. So that's what I'm thinking. That's where he probably is. But up until my knowledge, I don't know, and I don't care to know.
Good. I don't want you to know. I don't want you looking for him. Just wanted to make sure that was the situation. All right. Well, Ms. Tucker, I find there is a factual basis for your plea. Sounds like you and Mr. Richardson had a bumpy relationship. And if you were drinking or he was, or you were not taking your medications, if you got into a disagreement, it could sometimes get pretty violent. I'm glad no one got real seriously hurt. But that's the kind of thing that you need to stay out of going forward. It sounds like you're in a better place. I also find that your plea is knowing and voluntary. A voluntary plea is one where you're not feeling forced or pressured in any way to make the plea. Is that true?
That's true.
Okay, and a knowing plea is one where the defendant, that's you, understands all the things we've been talking about. Sounds like that's true also. Is that right?
That's true.
All right, then I'm going to accept your plea. I will follow the recommendation that your lawyer and the prosecutor have made. I will sentence you to 5 months to serve on this one charge. You'll get credit from the day you went into custody. So you should be released today or tomorrow. If you are not out by Thursday, you should reach out to Ms. Snyder and she'll reach out to me and we'll figure out what's going on, okay?
Okay, Your Honor. I misplaced Ms. Snyder's number. I wanted to know, can I get it again?
Yes, we'll do that in just a minute.
Okay.
Last thing I need to ask is, if you were here in court, I would have you sign your indictment. This is your indictment. But you're down at the South Annex. Do you authorize me, Ms. Tucker, to sign the indictment on your behalf?
Yes, sir.
And Ms. Snyder, may I sign for you?
Of course, Judge.
And Ms. Hall?
Yes, Your Honor.
Great. Ms. Snyder, are you able to give Ms. Tucker your number this way, or do I need to move you guys into the private room?
I'm going to send it in a direct chat to the South Annex screen.
Okay, let's make sure they got it and they'll get it to you.
Okay, I just sent it, so they should be able to.
Is that still you, Officer Milton?
Yes, sir.
Great. Did you get that phone number and can you get it to Ms. Tucker?
Yes.
Fantastic. Well, then I think we're all done. Ms. Crawford does not need to talk with Ms. Tucker because there's not a probationary piece. Thank you so much.
You're welcome.
Thank you, Judge.
Thank you, Your Honor.
Good luck, Ms. Tucker.
Yes, sir.
Is Ms. Marable here? Ms. Marable, how you doing? Your lawyer, Mr. Melnick, had a family emergency and can't be here. So he had another case we had to postpone. We need to postpone yours as well. Did you get something in the mail telling you to be here?
He told me that I had appeared and I was informed that he had family emergency. And so
Well, he's not able to, we learned about it from another lawyer. He's not in a position to be reaching out to folks right now. So you did the right thing by showing up. I do want to make sure we've got a good address for you because when I last saw you, I think it was on the screen. So let me look up your case right here and we'll figure out if we've got a good address. And if not, I'm going to ask you to fill out a form so you get stuff in the mail. But I promise you, you know this, Mr. Melnick will also be in touch with you. And he is very sorry that he couldn't be here today. But sometimes that happens. I'm sorry you had to wait a little bit, but I heard you telling the deputy that you were here and just didn't want to interrupt the other things we were doing. So I've got an address on Harvey Street.
Yes.
Okay, 46D Delta?
The apartment number is 28D.
28D.
Yes, sir.
All right. I'm going to ask the deputy to get a change of address form for you. And if you fill that out, we'll want it to go to the right department. And once you fill that out and give it back to the deputy, you're free to go. And Mr. Melnick will be circling back with you and we'll get you back in here to work through what we needed to work through, okay?
Okay, thank you.
And you're complying with all the conditions of your bond?
Yes, sir.
Good. All right. So once you finish that and you give it to the deputy, she's getting a pen, you're free to go.
Okay, thank you.
All right, let me see who else we have in court. I know we've got Ms. Howard on the phone. We'll probably do that. What case are you two here for?
Here today.
Okay, that's on. Are you Terica Day?
Yes.
Great. All right, that's on here. And that's Ms. Marable's family. How about in the back?
That's my family.
Oh, you got a big family. No wonder you made that bond. Everyone contributed. All right. Ma'am, you are? Ms. Marable, you're just not allowed to sit on that side? No, it's all good. You do what the deputy says. You travel with a big posse, Ms. Marable. All right. Well, thank you all for being here. And you're all welcome in the public courtroom. So when Ms. Marable comes back, if you all want to be here, that is okay. So if we get back to folks on the screen, who do we have in courtroom 2?
You got the add-on position number 2, Mr. Jett.
Mr. Jett, all right. I don't see Ms. Hodge. Are you handling this, Ms. Hall?
I am, Your Honor.
Okay. What are we do? Oh, this is a plea and arraignment, and maybe we talk about bond. What is it you think we're doing, Ms. Hall?
This is Miss. Yeah, I'm sorry. This is Miss Patel's case, and it's a negotiated plea.
Okay. Is there also thank you so much. Is there also a CP case that we'll be dealing with? I have something in my notes that Mr. Jett has a CP case. Is that news to you, Ms. Patel?
Yes, I checked the system and I did not see anything.
Okay, I'll check right now because I've got the number. No, that's for a different case. It just got copied over. So we are, okay. So what we're doing is taking a plea on Mr. Jett's case, full stop.
Correct.
Mr. Jett, can you hear me?
Yes, sir.
How you doing today?
I'm all right. How you doing this morning?
I'm doing all right. It's been a busy morning. Are you ready to take a plea in your case?
Yes, sir.
For us to do that, Ms. Hall is going to need to put you under oath, which she'll do in a minute. But I need to make sure you're comfortable moving forward in this setting. You have a right to be here in court, but you can waive that right and say, hey, I'm okay going forward with a plea online like this. Do you waive your right to be here in court?
Yes, sir.
You also have the right to have Ms. Patel sit next to you while we take the plea so that you can ask her questions and things like that. We can arrange for the two of you to speak privately. I can put you in what's called a breakout room, but we are able to take a plea with Ms. Patel plugged in the way she is. Are you okay with us handling it this way?
Yes, sir.
All right, you'll let me know if you need to speak with her in private?
Yes, sir.
Great. Last thing, it's important that you let me know if you have any questions at any time, either because you cannot hear what's going on or because someone says something that just doesn't make sense to you. Will you do that?
Yes, sir.
All right, Ms. Hall, when you're ready.
Thank you, Your Honor. Mr. Jett, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may lower your hand. Please state your true, correct, and legal name.
Dominic Antoine Jett.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone to school?
36, 11th grade, and got my GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
And do you understand that you've been charged with aggravated assault?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, do you waive formal reading of the indictment?
No waive.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Waive for the purposes of this plea only.
And do you waive moving forward on a copy of the indictment?
We do.
Mr. J, have you been arrested on these charges?
Yes.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
Has your attorney advised you of the minimum and maximum sentence to the charge that you're pleading to?
Yes.
The minimum and maximum for the aggravated assault is 1 to 20 years to serve. And do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 5 years to serve 1 commuted to time served, but the court does not have to accept that recommendation. The court can sentence you to the maximum on this charge, which is the 20 years to serve.
Yes.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I understand.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, I understand.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, I understand.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
How do you plead to the charge of aggravated assault in indictment number 20-SC174549?
Good.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
It's freely voluntary.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you. Your Honor, the state is aware of 4 prior convictions by the defendant between 16 and 19, 3 of which are in Fulton County. SC numbers are 17 SC 154563, which is an aggravated assault. Then there's 2 that were pled out together, one being 19 SC 165404, which is an aggravated stalking, and a 19 SC 172625, which is also an aggravated assault. Disposition dates of December the 13th, 2019. And the other disposition for the aggravated assault was October 5th, 2017. This was a case that existed when he took his conviction back in 2019. If you remember, Your Honor, we have talked about these cases before. This was a case that should have been disposed back in 2019. But I'll give you the facts in just a second. Had this case proceeded to trial, Your Honor, the state would have proven that on September 27th, 2019 at 546 Carlton Point Drive. That's in Palmetto, Georgia, in Fulton County. Officers were dispatched to that location in reference to a male beating on a female. Officers met with the victim, Miss Cynthia Hughes, who stated that her husband went through her phone. They started to argue, and then he attacked her by grabbing her arm and neck, leaving a scratch on her face. She did indicate, or officers in their report indicated that the victim said that she was choked during this incident. That is why the charge was indicted as aggravated assault. I spoke with the victim during in which time I've had this case. She did tell me that the defendant never strangled or choked her, that it was simply he took her phone and there was a disagreement about the phone. He did grab her arm, or she did say he grabbed her arm, but there was never the escalation of the strangling. That is why we have come to this negotiated agreement of 5 to serve 1, Your Honor. That is all from the state.
Is Ms. Hughes the victim in the aggravated stalking case?
I'm not sure, Your Honor. I didn't look for this particular plea. I didn't relook at the things that we had already discussed prior, so I'm not sure, Your Honor.
Okay, well, I'm just looking around. That is quite a history of family violence. So I just want to make sure we are not letting someone who is dangerous to the women in his life out without something more serious than we'll put you on probation. I'm noticing he got his probation revoked in the 2017 case a couple times. Trying to find the indictment on that one. 2017, the victim had a knife placed to her neck, Cynthia Hughes, and Mr. Jett did not do well on probation in that case. Let me go back to his list of cases. Comes up 15 times in the system. Simple battery, family violence battery. Let's see, there's an open civil case between Ms. Hughes and Mr. Jett. How about I get to the next page? I see. All right, I need the ag stocking case number again, please.
Okay.
I have it. It's 19 SC 164504, and it is the same complaining witness.
Okay.
But I have more information to provide the court.
Okay, I'll take it in a minute.
However they want to do it, because I did that, I wouldn't accept whatever they got, whatever, you know what I'm saying? So it's my family, you know what I'm saying? I was in that program, they were talking about helping me, man. You know what I'm saying? I got 5 kids, you know what I'm saying? You know what I'm saying? They were talking about helping me, so I
Your Honor, Ms. Rolak wanted me to inform you that the victim, Ms. Hughes, is on the Zoom. Last time we had this big discussion, we went through, Ms. Patel will probably remind you of everything that we did already on the case, or we talked to you about already. She wasn't present in last court, and you did want to kind of have a conversation, but she is present now.
Okay, well, let me just see what Judge Adams did with the aggravated stalking. All right, Ms. Patel, why don't you tell me what you wanted to tell me?
Right. So, Your Honor, initially we put this up as a negotiated plea way back in December. At that point, Your Honor wanted to give Mr. Jett a 5-serve 18 months, and he withdrew his plea. We were then back on a calendar in July, and that's when we discussed this case with Your Honor and discussed the fact that we had negotiated the 5-serve one and discussed the case. Your Honor had indicated that you were concerned with the fact that he might be released and not serve the full year that he was in custody for. And so Your Honor had put a warrant on him so that when he was released from DOC that he would come back to Fulton County. But when we discussed it, Your Honor indicated that as long as he had served the year, Your Honor would be agreeable to what Ms. Hall and I had worked out. Initially in December, when we had pre-tried it, your concern was that Ms. Hughes was not in court, even though Ms. Hall could talk about what she'd spoken to pertaining to the case at hand, but she did not have information about the other cases at the time. And so he has served the full year. He went into custody, I believe, October 30th of 2019. And he is back in Fulton County. I just wanted to add that they are getting a divorce. It may or may not have been finalized. I'm not sure. He was served with the paperwork in prison, but I think that Ms. Hughes might be able to provide more information on that. But in terms of them being back together, that is not a concern. He's moved on, she's moved on. I believe they have children together, and so she just wants to make sure that they can continue to co-parent, but that there is no him going back to her or her taking him back or anything like that. And he will not be residing with her upon release. I believe he has a girlfriend and or fiance that is on this call, and he'll be staying with her.
Okay. Ms. Hughes, are you there? Ms. Hughes? Who's Asia Jett?
It's Miss Hughes, Your Honor.
Oh, all right. Is that you, Ms. Hughes?
Yeah, that's when it happened. What you saying? They saying that they're gonna reinstate those.
Can you hear me, Ms. Hughes?
Oh, you said they're gonna give me. Yeah.
Ms. Rolak, are you able to assist?
I will call her, Judge. I've been texting back and forth.
Okay. Mr. Jett, you went into custody just before Halloween of last year?
Yes, sir.
Yes, sir. Yes, sir.
Ms. Patel, if there's more you want to share with me, I'm happy to hear from you while we work out a connection with Ms. Hughes, if I cut you off.
Sure, Judge. The only thing that that I want to add is that he does have his high school diploma. At the time that we initially had this case, he was going to be able to go back to his employer, which was McDonald's. I'm not sure if that's the case for him anymore, but he does have 3 kids. They do reside, my understanding is with Miss Hughes, and he does intend to help co-parent with Miss Hughes with those children. But I spoke with his girlfriend, Miss Crawford. I got her address. She lives in Union City with her mother, and that is where he would reside if he were released.
Okay, and mom lives in what part of Metro Atlanta?
Oh, Miss Hughes?
No, where does I thought you just said Mr. Jett would be residing with his mother.
Sorry, his girlfriend and her mother.
Oh,
and they
okay.
live in Union City.
Union City, okay.
I believe the girlfriend is on the call, the Zoom call as well.
Yes, she's on mute.
Is that the Galaxy A10e?
I believe so. And then I think we have Miss Jett back. Or I mean Miss Hughes.
Okay. And you know, Ms. Rolack, I'm fine if Ms. Hughes can connect just with audio. I'm just interested in hearing her perspective on this. She has been the victim of a number of cases which Mr. Jett entered a plea, all of which involve domestic violence.
Yes, Judge, she is actually trying to connect the audio, but I think that it's best that she speaks through my.
Okay. Well, why don't we try that? And I'm happy to keep it simple. I just want to know her thoughts about a sentence in this case that would allow Mr. Jett to get out now. He's served a year. It's a little less than I had thought was appropriate a bunch of months ago, but it's not a 5 served 1 reduced to time served. He will have served a year in connection with the host of things that he did to Ms. Hughes, and I wanted to get her opinion on that.
Okay, Ms. Hughes, can you hear me? Can you hear me? The judge wanted to know how you feel about the sentencing. They can hear you.
It's about the sentence something.
So
the judge wants to know how you feel about sentencing.
Honestly, I just want to get on his divorce papers. That's what my main concern is.
Her main concern is to get him served with the divorce papers.
Okay. Does she have a concern about Mr. Jett not being in jail anymore?
Do you have any concerns about him being out, not being in jail anymore? I really don't. I just want him to stay away from me and my kids. That's really it.
Okay. Thank you. Thank you, Ms. Hughes. Ms. Patel, staying away from the kids is a problem because Mr. Jett, of course, has a right unless Judge Schwall has the divorce case. He may decree otherwise, but until he does, Mr. Jett would have a right to see the kids. But he doesn't need to be around Ms. Hughes in any way. Does he understand that it may be a little complicated, but that he does have a right to see the kids?
Yes, I have not discussed with him the option of pursuing a third party to arrange visitation, but I can certainly do that after the plea in a breakout room.
Okay. All right. Mr. Jett, we've been talking about you a lot. You've been listening patiently. Is there anything you want to share with me before we work through all this?
Yes, sir. As far as divorce, I had been served my divorce papers. I asked her for it as well. We both agreed upon a divorce. That's why we had a civil and peaceful divorce. As far as the children go by, we only have one child together, which is the youngest. And as far as me seeing my daughter, being around my daughter, which will be going through the courts upon the divorce for visitation rights. So that won't be an issue or a problem. As far as me and her staying away from each other, we agreed to that, and I'm gonna stick to that. We like my Ms. Patel said, we both had moved on. I had my girlfriend, she had who she dealing with, and that's fine. We just gonna co-parent, and we both understand that.
All right. So Ms. Hughes has 3 kids, but only one of those kids is your biological child?
Yes, sir, the youngest one,
Okay, and what's her name?
Asia Jet.
Oh, okay, there's where Asia Jet's coming from. All right, so that's your daughter. How old is Asia Jet?
She turned 7 while I was in prison.
Okay. All right. Where'd you get your GED?
I got it when I was in Maryland, online. I took a class online.
Do you have other kids besides Asia?
Yes, sir. I have a son that's 20, and I have another daughter that's 7. I have 2 7-year-old daughters and a 20-year-old son.
Where is your 20-year-old son?
My son, he in Baltimore with his mother, and my other daughter in Baltimore with her mother.
Baltimore.
Yeah, they in there with their mothers. They stay with their
Okay.
mothers.
All right. Well, Mr. Jett, I find there's a factual basis for your plea based on what I heard happened on September 27th of last year. Were you living down in Palmetto at the time?
Yes, me and my ex-wife was living together at the moment.
Okay.
We tried to work our marriage out at the moment.
I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. Is that true?
Yes, sir.
Okay, and knowing means you've understood all the things we talked about. Are there any things you did not understand, or do you feel like you know what's going on?
No, sir, I understand everything. Just like to put everything behind me and get on with my life.
Okay, and we let Ms. Hughes get on with her life.
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act. What that means, Mr. Jett, is that while you're on probation, which you will be for 4 years in this case, if you have a minor or technical violation, you and probation will work that out. But if it is something more serious, you get arrested, or I get information that you are bothering Ms. Hughes in any way, that situation comes back to me, and you and a lawyer representing you will work through what the consequences would be for those kinds of allegations. I am going to sentence you to 5 years to serve 1 year. You'll get credit for the time that you've been in. I'm probating the balance, so that's 5 years probation. Special condition number 1 is that you will complete the Family Violence Intervention Program. Special condition number 2 is that you will have no contact with Ms. Hughes other than related to your divorce proceedings. And number 2, related to spending time with your daughter, Asia. You're going to need to work with Ms. Hughes so that you can spend time with Asia. But beyond those 2 topics, you're to have no contact with Ms. Hughes. That means no calling, no writing, no texting. You don't put something on social media that says anything about Ms. Hughes. It also means that no one close to you is doing that either. So you can't do it indirectly. You couldn't have your new significant other or a brother or a friend try to reach out to Ms. Hughes to say, why are you being this way with Dominic or anything like that. If Ms. Hughes provides evidence to the DA's office that someone is harassing her on your behalf, that's going to be your problem and not the someone's problem. Does that make sense?
Yeah, I understand everything that you're saying.
Good. All right. Ms. Hall, any other conditions you'd want to see for probation?
No, Your Honor.
Okay. Ms. Patel, does this plea potentially trigger any probation revocation issues for Mr. Jett?
I don't.
Judge, I think the revocations were handled with Judge Adams in December of 2019.
Okay, and the basis, partly at least, for the revocations were these new charges?
That's correct.
Okay, that was how I saw it on the screen. And Ms. Patel, if something happens where the basis for the revocation is this case, bring it to my attention so that I can work with that judge to say we thought we had wrapped all that up.
Yes, Judge, I will.
Okay. I think that's it. Mr. Jett, do you have any questions about the sentence that I described?
So basically, it's a 5-1. Ran concurrent with the 5-1 I got. Commute the time served.
It's not commuted or reduced. Judges can't commute sentences, but it's 5-1, but you've already done one. And if you haven't, you only missed it by a few days, and so you do a few more days. But Ms. Patel believes that you went into custody in late October of last year, and now we're in November, so that's a year. So you'll get credit from that. We'll research it to make sure that's when you went into custody. So you've done your year, and you ought to get out in the next day or so. If that doesn't happen, you need to reach out to Ms. Patel, and we'll figure out what's going on.
Okay, now I understand.
Okay, two more things. One, if you were here in court, Mr. Jett, you would be signing your indictment, but you are there at Rice Street. Do you authorize me to sign the indictment for you?
Yes, sir.
Ms. Patel?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Okay. The only other thing we need to do is you need to give Ms. Crawford, who works with probation, she's not your probation officer, but she works with probation, an address and a phone number of how to reach you when you get out. And she's going to give you a reporting date for when you need to show up at the probation office to say, I'm Dominic Jett, and you'll meet your officer, that kind of stuff. Okay?
Yes, sir.
All right. Ms. Crawford, do you guys want to go into a private room, or you just want to talk right here?
You can send us to a private room, Judge.
All right, we're going to do that. Let me figure that one out. Breakout rooms.
Yeah, I gotta go speak to her. Try to continue my probation. So on Friday.
It's Crawford and there we go. All right. Ms. Rolack, did Ms. Hughes have any questions?
Not in particular, Judge. Her questions referred to the civil matter.
Okay. Well, she should be able to get things to Mr. Jett more readily once he gets out. Thank you, Ms. Hughes, for dialing in. I'm sorry we weren't able to hear from you directly. I wish you and your family the best as you move forward. What do we have next? We've got Ms. Howard on the phone, and we've got someone in court here as well. I'm happy to take them in whatever order you guys want. I don't want Ms. Howard's phone to die.
Yeah, I'm prepared to go forward with Ms. Howard.
Okay.
Ready as well.
All right. Ms. Howard, you there?
Yes, sir.
Can you hear me?
Yes, sir.
Good, we can hear you. Am I remembering correctly that we were going to do this once before, but your phone died on us?
I'm fully charged.
Fully charged. I like to hear that. Then we're going to do the plea. Ms. Howard, you have the right to be here in court and to have Mr. Franklin sitting right next to you. Hold on one sec. Are you okay transition? Great. And have Mr. Franklin sitting with you. But you can waive those rights and go forward with a plea with you sitting comfy there in the back seat of that car. Are you comfortable going forward with the way we are?
Yes, sir.
Okay, so you're waiving your right to be in court. You're waiving your right to have Mr. Franklin by your side. If you need to speak with Mr. Franklin in private, let me know, and I'll move the two of you into what we call a breakout room, okay?
Okay.
All right, Ms. Hall's going to put you under oath. Once you're under oath, it's important that you answer all her questions truthfully and completely, all right?
Yes, sir.
You're up, Ms. Hall.
Ms. Howard, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
Denise M. Howard.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
43 all the way.
All the way as in high school diploma?
Yes, ma'am.
Are you able to read?
How old did you say you were?
43.
43? Thank you.
Are you able to read, write, and understand the English language?
Yes, ma'am.
I'm sorry, excuse me. Do you understand that you have the right to plead either guilty or not guilty?
Yes, ma'am.
I'm sorry. Um, my apologies. Do you understand that you've been charged with? I made another mistake. Your Honor, for the record, the state is null processing counts 1, which is the aggravated assault object with, and we are reducing count 2, which is aggravated assault object with, to affray. The statute code is 16-11-32.
Okay.
Ms. Howard, do you understand that you've been charged with aggravated assault being amended by the state to affray?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Franklin, about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes.
Do you waive moving forward on a copy of the indictment?
Yes, ma'am.
Ms. Howard, have you been arrested on these charges?
Yes, ma'am.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
No, ma'am.
Has your attorney advised you of the maximum of 12 months to serve on the sentence, the charge that you're pleading to?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means the state will recommend a sentence of 15 days to be reduced to time served, but the court does not have to accept that recommendation. The court can sentence you to the maximum on that charge, which is the 12 months to serve.
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury. I'm sorry, Ms. Howard, I'm gonna give you a list about 8 or 9 different things, and then you can respond if you understand at the end of this particular section. The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand all the rights that you're giving up?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the single charge of affray in indictment number 19-SC-168770?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state is aware of one prior conviction by the defendant. It dates back to 98. I didn't pull that charge. If you want more details, I'll give that to you. But if this case proceeded to trial, the state would have proven that on October the 19th, 2018, at 504 Boulevard Northeast, Atlanta, Georgia, in Fulton County, officers were dispatched to their location in reference to a fight. Your Honor, you may remember this was a group of girls fighting. When officers arrived, the set of girls that was still remaining on scene told officers that Miss Howard and her daughter had gotten into a fight with them, hit them with a bat. Officers at that time went over to across the street where Miss Howard, the Howards were located, and they did locate a bat on the ground, at which point they determined that the Howards were the aggressors, and they did arrest both of them. Since this case has been indicted, one of the victims in the case was killed or murdered, and since even before we found out that information, we had came to a negotiated agreement, understanding that it was a fight between everyone, and it wasn't as serious as the aggravated assault charge portrayed. So that's where the reduction comes from. The no price comes from the victim who is no longer with us, and that is all from the state.
Okay. Mr. Franklin.
Not a bunch to add, Your Honor. The one additional detail that I will give you is that the moment at which Miss Howard, Denise Howard, was arrested, they said something to her like, you know, we're arresting you because you swung a bat at someone. And you can hear Miss Howard say to this crowd of other young women, you know, I didn't have the bat, I took the bat from y'all. And so I think that the bat was originally produced by the other party, and that in this big commotion that she took the bat and swung, possibly just because it's a bunch of people and she's trying to get her daughters away. One of her daughters, whom at the point in time was pregnant. So I think she was just kind of being a mama bear under these circumstances. And I think her lack of history goes to support that. But nevertheless, it is a set of activity that does fit the reduced charge. And we ask that you accept the plea as negotiated.
Okay, thank you for sharing that. And it sounds like your client was maybe trying to be the one responsible person in the area by getting that bat out of the way. Ms. Howard, how long were you in jail as a result of this?
2 weeks.
Okay. And that was back in 2018. Everything been okay since then?
Yes, sir.
All right, so were you already a grandma, or did you become a grandma as a result of the birth of the child from your daughter who was pregnant?
I already won.
Already won, all right. Well, I hope everything is going okay. Do you have any questions about anything we've talked about?
No, sir.
Well, Ms. Howard, I find there's a factual basis for your plea to affray, which basically means everyone out there was sort of tumbling around and fighting and yelling. I also find that your plea is knowing and voluntary. That basically means you've understood the things we've talked about, and no one is forcing you to take this plea or has promised you anything other than the offer that you got. Is that true?
Yes, sir.
Okay, then we'll go forward with it, and I'll accept your plea. I will sentence you to 15 days to serve, but I'll reduce that to time served just in case you did a little less than 15 days. So you're not going back into jail. It's a misdemeanor, so you're done. You don't have any probation or anything like that for this case. Ms. Crawford, I should have asked you, was there any other criminal history? Ms. Hall mentioned a case from way back in '98. Anything else?
That's it, Judge. She just has two cases from '98. One was the simple assault misdemeanor. The second one was controlled substance felony, but they're both inactive.
Long gone. Okay. All right. Thank you. So that'll be your sentence, Ms. Howard. If you were here in court, and you've now heard me say this like 3 times, you'd be signing your indictment, which I'm holding right here. Do you authorize me to sign the indictment for you, indicating that you've pled guilty?
Yes, sir.
Great. Mr. Franklin?
Yes, sir.
And Ms. Hall?
Yes, Your Honor.
Great, then I'll sign the indictment. We'll take care of that. And I think that's it. Anything else, Ms. Hall, on Ms. Howard's case?
Nothing further from the state.
Mr. Franklin?
Nothing further.
All right. Well, Ms. Howard, that's it. If you've got any questions about what's next, you can just reach out to Mr. Franklin, but your case is closed, okay?
Thank you.
You're welcome. Be safe.
You too.
And I believe that leaves Ms. Day, very patient. Ms. Day, if you don't mind coming up to the podium or sitting at the table that is to your right, so that Ms. Patel can see you. And we'll need Ms. Hall to be able to hear you. Ms. Nelson, I've got a lot of paper up here now. Did you already send Ms. Day's indictment, or are you sending that to the printer now?
I'll send it now. I don't remember if I did. No, I did not send it. I'll send it now.
Great, thank you. It's been working well, the printer. Mr. Forte, I think this is our last item. Do you want to finish this, or do you need to take a break?
We're good.
You're good? Okay, we'll do that. All right, well, good morning, Ms. Day. We're here, I think, to take a plea in your case. Is that what you're hoping to do? All right. Ms. Hall, are you able to hear Ms. Day?
Yeah, that's why I don't need it.
You say, good morning, Ms. Hall.
Good morning, Ms. Hall.
I can hear you, Your Honor.
Okay, then that'll work. Why don't you sit in the middle seat, because then you'll be closer to the microphone. You can bend the microphone towards you a little bit. Excellent. All right, and Ms. Patel, were you able to hear your client?
Yes, Your Honor.
Great. So Ms. Day, in just a moment, Ms. Hall's going to put you under oath. You've now seen the process. Once you're under oath, it's important that you answer all the questions truthfully. You are here in court, so you're not waiving any rights in terms of being in a public space. Ms. Patel is appearing remotely from her office. Do you waive your right to have your lawyer sitting by your side for this plea?
Yes.
If you need to speak to her in private, we can make that happen. You need to step outside and talk to her on the phone, but she can give you a number to call. Let me know if there's something you need to speak about in private with Ms. Patel, okay?
Yes.
All right, Ms. Hall.
Thank you. Ms. Day, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you please state your true, correct, and legal name?
Sheriff and Day.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 37 and I finished my second year in college.
Uh-oh. As long as the court reporter heard you, I couldn't hear what you said.
37. Go ahead.
And second year college, I'm sorry.
Did you hear that, Ms. Hall?
I heard 37, but I didn't.
Okay, she got through 2 years of college.
Oh, okay, okay. Are you able to understand, are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with Your Honor, for the record, the state is reducing the trafficking in illegal drugs count 1 to possession of MDMA with intent to distribute. And
Okay, all the other counts are as is?
And we're no pricing, we're no pricing possession of cocaine, count 3, and count 4, criminal damage to property in the 2nd degree. And I will get you the code for the MDMA in just a second.
Okay.
Ms. Day, do you understand that you've been charged with the following offenses? Trafficking and illegal drugs being reduced to possession of MDMA with intent to distribute, possession of a controlled substance in Schedule 1 or 2 with intent to distribute, and battery family violence.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Waive for the purposes of this plea only.
And do you waive moving forward on a copy of the indictment?
We do.
Ms. Day, have your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
Minimum maximum for MDMA with intent to distribute and possession of a controlled substance in Schedule 1 or 2 with intent to distribute is 5 to serve 30 years. I'm sorry, the minimum is 5 to serve, minimum 5. I'm sorry, I don't know what's going on with my brain at this moment. The minimum maximum is 5 to serve, 5 to 30 to serve. And the maximum for battery, family violence is 12 months to serve. You understand, Ms. Day?
Yes, ma'am.
I'm sorry. Let me know if I need to explain anything. I understand that I'm having an issue right now. Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence for possession of MDMA with intent to distribute and possession of a controlled substance in Schedule 1 or 2 with intent to distribute, both 5 years to serve 1, commuted to time served, and then 12 months probation for the battery, family violence. Special condition of your probation is that you enter and complete drug court, but the court does not have to accept that recommendation. The court can sentence you to the maximum on these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
You understand this is a guilty plea, which is permanently recorded on your criminal history.
Yes, ma'am.
You understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts.
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation? This as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charges of possession of MDMA with intent to distribute, possession of a controlled substance in Schedule 1 or 2 with intent to distribute, and battery in indictment number 19SC 170539?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state is aware of 5 prior convictions by the defendant dating back to 2004. 3 of those convictions are from 2004 and 2007. The most recent convictions are disposition date out of DeKalb County of possession of a firearm by a convicted felon. That number is 17 CR 3757, and that disposition date is January 31st, 2018. Excuse me. And then there's a Fulton County case of theft by taking, disposition date of August 30th, 2018. And that number is 18 SC 160121. And
The cases from 04 and 07, I don't need the case numbers, but what were the lead charges?
1 second. Possession of cocaine from 2004, possession of cocaine with intent to distribute 2004, and forgery in the first degree 2007.
Okay.
And
Ms. Crawford, are any of the cases we heard about still open?
No, Judge, she doesn't have any open active cases.
Thank you. All right, back to you, Ms. Hall.
You're welcome. And had this case proceeded to trial, the state would have proven that on August the 5th, 2019, at 500 10th, the number 10th Street, Northwest Atlanta, Georgia, in Fulton County, officers conducted a traffic stop after noticing the victim screaming out of a car. They stopped this vehicle. They investigated. They learned from the victim that the victim is the defendant's, was the defendant's wife at that particular time. And they learned that they were splitting, and apparently the defendant was supposed to be dropping the victim off somewhere other than where they were currently living. During the transporting of going somewhere new, there was a disagreement in the car or argument, or something happened to the point of the defendant putting her hands on the victim. In this case, the defendant at some point broke the defendant's phone by throwing it out of the car. And during which time the police were on scene when the defendant learned that she was going to jail. She did mention some other illegal something being in the car, which caused officers to search the vehicle. They did find what they noted to be MDMA. However, it came back as meth. I did have conversations with the victim in this case because it was a situation where I was being told that none of the defendant's items were inside of the vehicle. Only person's items was in the vehicle was the victim who was leaving. And so she packed all her things, or the defendant packed all her things and put them in the vehicle. I did speak with the victim a couple of times in this case. And after speaking with the victim a few times and understanding everything that happened, and even trying to figure out who the drugs belonged to in this car, because they were found on the front passenger floor inside of a bag. That bag did have the defendant's work shirt in that bag. But after speaking with the victim, I was informed that apparently the defendant does some type of driving side job, and she had never known her to do this type of drug. It was her position that she didn't know anything about the drugs at all, the victim. And after talking with Ms. Patel, that was also the same position from the defendant, was that it wasn't her drugs and she was not aware of them. So that is why we've come to the agreement of reducing the charge from trafficking to this MDMA charge with intent to distribute. Although I may have been persuaded that she wasn't aware of the drugs in the car, we wasn't so willing to drop all of the charges because, as you can see in her history, there are drug issues in her history. But that is all from the state, Your Honor.
Okay, thank you for sharing that. Do you know, Ms. Hall, if Ms. Day has been accepted in the drug court, or have we simply done the referral?
She's been accepted, Your Honor.
Okay, thank you, Ms. Patel. Ms. Patel, what do you want to add?
Your Honor, so this case has been lingering for a minute, and part of the reason is because Miss Day was revoked on parole for the firearm charge based on these charges. And so she went to prison for 6 months and was released. During that time, I was able to obtain the the body camera footage for this incident. In the body camera footage, the victim, when police are talking to her, says, "Oh, and if you check this backpack that's in the passenger seat, that all belongs to her and that has drugs in it." And so they searched the backpack, it has the drugs, but all of the contents in the car did belong to the victim. And clearly the victim knew that there were drugs in the car by indicating to the officers that they'd find it inside the backpack. With that being said, I think that this case is a good opportunity for Miss Day to get the help that she needs. I was very concerned that when she was going to be released on parole, that she would just disappear back onto the streets, but she immediately called me and my social worker, and she got herself enrolled into outpatient treatment while we worked with the state to try to get her into drug court. She has been at Winway, which has been providing her with drug and mental health counseling. Since she's been released, she's realized she has not done a good job of coping with some problems that she had when she was younger, which had ultimately resulted in her starting drinking and using drugs. It was her suggestion that Winway also be incorporated into her plea, but I was hesitant to agree to that because I just don't know if there will be anything that conflicts with drug court, and Miss Day is already doing part-time work. Her work has indicated that they'll be flexible with drug court, but I didn't want to put too much on her plate when she starts. But drug court, they are aware of today's plea. They're just waiting for all the paperwork to be done, and then she'll be able to start orientation. But we're hopeful that she stays clean. She's been doing a good job since she's been released from prison and has been able to maintain gainful employment. And so hopefully she is able to continue on the right path.
Ms. Hall, thank you, Ms. Patel. Ms. Hall, I don't know if it sounds like your office has had some contact with Ms. Johnson. Did she have any victim impact statement she wanted to share, or anything you want to relay to me as to her view on sentencing?
She didn't have an impact statement, Your Honor, that she wanted to relay. She did inform me that she knows or she's aware that the defendant has some drug issues, not selling, but within herself, or using, and that she didn't really have much to say as far as their relationship. She did say that they were either gotten divorced or going through the divorce, and they haven't spoken in that. But as far as the sentencing, she didn't really mention much other than she does think that she needs help with the drug problem. That's it.
Okay, but you don't have a perspective on whether there should be a no contact provision.
Oh, I'm sorry. I misunderstood. No, oh, sorry. I did ask her about that. She said that she didn't have intentions on speaking with her, but she wasn't scared of her and she didn't need a no contact order in place.
Okay, thank you. Ms.
You're
Day, what's your part-time work?
I work for Pix. It's the inventory service. We do like grocery stores, retail.
Okay. And what's Winway?
That's I was in their program a couple years back and I tried to get up before I got incarcerated again. It's like a mental health substance abuse. They coincide together with your mental health and help with substance abuse.
Do they provide housing or counseling? Or
counseling, and I believe they can provide you housing.
You have your own housing?
Yes, I do.
Okay. Ms. Johnson is not a part of your life anymore?
We have a child who is not my child, but the child knows of me, so I still deal with the child in my life.
Okay. And that's how you would come into contact with Ms. Johnson, is to be present in the child's life?
Yes.
Okay. What substance or substances do you struggle with the most?
Really alcohol.
Okay. That is a important part of what drug court deals with. It doesn't have to be what they call the hard stuff. Alcohol, as you know, can be just as disruptive to family, career, etc. Drug court is a many-month commitment. You don't do drug court for 3 weeks and then we throw a party for you and you're all done. You understand that?
Yes, sir.
There are 2 different drug court judges. I happen to be one of them, and I'm telling you that just because you shouldn't be surprised if you see me again in a month, because the judge meets with the client on about a monthly basis, a little more frequently early on. But if you and I are working together, that's just a coincidence. It's sort of 50-50 whether you get the other drug court judge or you're working with me. But it shouldn't be an issue that I handled your case before. I have a number of clients in drug court whose cases I had originally. Anything else you want to share with me?
No, sir.
You think that your work with PICS will be flexible enough that you can also take care of your drug court obligations?
Yes, they're very supportive.
Great. Well, that's a good employer to have. All right. Well, Ms. Day, I find there's a factual basis for your plea in this case. It sounds like August 5th of last year was a tumultuous day for you and Ms. Johnson. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to take this plea and no one's promised you anything other than the offer that the state made. Is that true?
Yes.
And a knowing plea is just one that a defendant makes because she understands what's going on. Have you understood all the things we've been talking about?
Yes.
All right, then I'm going to accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And what that means is that while you're on probation, the first part of which will be in drug court. You really won't see much of a probation officer. But while you're on probation, if you have a minor violation of your probation, miss a meeting or something like that, you and probation work through that. You don't have to come in front of a judge. But if it is a major violation, you get arrested again, you get kicked out of drug court, that will come back to the drug court judge, actually, is the one who will handle that. And as for your sentence, on counts 1 and 2, I'm sentencing you to 5 years to serve 1. That 1 year will be reduced to the time you've already served. Counts 3 and 4 are being dismissed by the state. Count 5, I'm sentencing you to 12 months to serve. That'll be reduced to time served as well. And all those counts are running concurrently at the same time with each other. So the net effect of all that is you've got 4 years of probation, and it will be a special condition of your probation that you enter into and complete the drug court program. And special simply means that if you are terminated from drug court because you violate their rules or their procedures, the judge who's handling your revocation can use all the time remaining of your probation to fashion a sentence. Okay. Ms. Hall, anything else for Ms. Day?
Nothing further from the state, Your Honor.
Ms. Patel, will Ms. Hall, will Ms. Day how will she know when to show up at drug court?
Drug court has her phone number, and so they will be arranging with her for her orientation date.
Okay. And Ms. Crawford, does Ms. Day also need to show up for an orientation day or a sign-in day for probation?
Yes, Judge. So I need to get an address. I already have a report date for her, but I just need to get an address and emergency contact person.
Okay. So in just a moment, Ms. Day, you're going to share with Ms. Crawford, who works with probation, your address and a good phone number so that if you miss your date, they can call you. You don't want to miss your date because they'll also send me a warrant to sign. But that will need to be the address where you're staying right now. And then it sounds like drug court will contact you when you need to show up for orientation. That's your other important date. If you don't show up for orientation, they send you a warrant to sign saying this person apparently isn't serious about drug court because you didn't show up for the first day. If a few weeks have gone by and you have not heard from drug court, don't assume that they just forgot about you. Reach out to Ms. Patel so she can figure out why drug court has not contacted you. Okay. All right. So if you could share with Ms. Crawford, what's a good address for you?
6496 Crooked Creek Trace. That's in
I didn't get
Crooked Creek Trace, 3 words. So a creek that's not straight.
Yes, sir.
Crooked Creek Trace.
Okay, what city and state?
Lithonia, Georgia.
Your zip code?
30058.
Do you have a telephone number?
Yes, ma'am. 678-524-4278.
Okay, what about an emergency contact?
Deborah Day. Her number is 770-484-8205.
Okay, and you're gonna reside in Lithonia, Georgia?
Yes, ma'am.
What county is that?
DeKalb.
Okay, so I'm gonna have you report to DeKalb County. Do you have something where you can write down your report date and the address?
Can I put it on my phone?
Yeah, that's fine.
Yes.
That's where it needs to be.
Okay, your report date will be December 1st.
December 1st.
At 9 a.m. That's on a Tuesday, December 1st. The address will be 2910 Miller, Miller Road, Suite 150. And that's in Decatur, Georgia.
Yes, ma'am. And what
And
time?
I can also give you a telephone. 9 a.m.
So December 1, 9 a.m. Did you get that whole address?
Yes, sir. I know where it's at. Yes.
She's gonna give you a phone number too.
Okay.
Yes, and their telephone number is 770.
Yes, ma'am.
593. 7437.
Okay.
Ms. Day, Lithonia and drug court are far apart. Drug court is over by the county jail. Hope Hall is what it's called. How do you plan on, from time to time, you'll need to actually go to Hope Hall. A lot of it is virtual right now because of the pandemic, but some of it's in person. For example, your regular drug screens, you got to get to Hope Hall. How will you get from Lithonia to Hope Hall?
I have a car. Yes, sir.
Done. All right, a lot of drug court clients don't, and when I heard Lithonia, I'm like, it's gonna be an issue. So you're all squared away.
Yes, sir.
Good. All right, Ms. Hall, anything else in Ms. Day's case?
No, Your Honor.
Ms. Patel?
No, Your Honor.
Okay, Ms. Day, you are all set. You've got one reporting date, December 1. Hopefully drug court will get in touch with you soon. Their orientations are on Wednesdays, so that will be when you start. Maybe next Wednesday, it's not today. It could be the Wednesday after that, but hopefully they'll be in touch with you soon. Okay, thank you.
Thank you.
All right.
We did sign the indictment, right?
Oh, right, sorry. Let me do that last thing. Thank you, Ms. Hall. Ms. Day, in normal times, you and your lawyer sign the indictment saying, yep, pleading guilty, all that stuff. But we don't hand papers around so much right now. Do you authorize me to sign the indictment for you for your guilty plea?
Yes, sir.
And Ms. Patel?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Good catch, Ms. Hall. Thank you. Now that's really, really it. You can go.
Thank you, sir.
And with that, I think, my friends, we have taken care of the calendar. Was there anyone you thought we were dealing with that we did not? Well, thank you. This was another real productive day. You guys have been moving a bunch of cases. I appreciate that. I think more important than me appreciating it, the clients appreciate it. I appreciate in particular the way we jumped on Mr. Grimes' case. That was getting to be pretty scary, and it was important that we prioritize that. So thank you for all the work you've been doing with these different things. And I think to get the rest of the day off, I have a motion for a new trial this afternoon, tomorrow.
No, we got court.
We got something at 9. It says pre-trial hearing. If you've got cases on that, I guess you need to be there. And Friday you get off. I know you're doing plenty of work, just meaning I won't be bugging you on Friday. Ms. Hall, anything else?
Nothing further from the state, Your Honor.
Ms. Patel? Mr. Franklin?
Yeah, I sent a private message to Ms. Nelson with Mr. Grimes' address. He would be living with his mother.
Okay, great. Then she can get that to me and we'll take care of bond in the entering auto case. And then Ms. Crawford will get to me. I guess Ms. Nelson will need to send that to Ms. Crawford because I want to put that on the revocation order as well. So both things are saying live with mom at address X.
If he can give it to me now, I can go ahead and write it down so that I can send it to Ms. Nelson and she can file it.
All right. He will send it to you via chat.
Okay.
And I was making sure that Ms. Nelson did receive it. I don't know if she was looking down at her chat box or not.
No, I wasn't. Thank you for bringing that to my attention.
No problem. I know you usually respond back and say, got it, thanks. I was like, oh, she hadn't responded. Let me hang around.
I've got several things going on in here.
Can imagine. All right, folks, thank you so much. Happy November. Go watch the ballot counting.